perfectly.
Okay, fantastic. Steve, I see you're there. Can you hear me?
Yes.
Okay, wonderful. All right, so you guys hold on for a second. Let me text Ship and see if he's ready to join. So hold on. Okay, so I've sent him a message. We'll see if he can join here in a few minutes. All right, so tonight, you guys, we are going to be talking about the Fisher case, which is spelled Fischer, in the Supreme Court, which is going to be argued on Tuesday, this coming week, this week. And then, as per usual with the Supreme Court's procedures, we probably will not get a decision from them until sometime between now and it used to be pretty solidly the end of June 30th, but during the pandemic, and I've noticed, I think last year too, I could be wrong about this, but I think last year also, they issued some decisions sort of between June 30th and the 4th of July. So maybe the court is stretching that a little bit, but historically, they would render their decisions each term before the end of June 30. So that's when this will almost certainly come out. Occasionally, they will say that they still don't have an answer and they want the case to be re-argued in the next term or to carry it over, but that's very rare. So in practical reality, we're going to get a decision on this case by the end of June. And this case is about, primarily at this point, it's about the January 6th protesters, demonstrators, rioters, whatever it is we want to call them, and whether or not the Department of Justice's application of the federal obstruction statute to the riot that day is allowed under the terms of that statute. So that's primarily the issue. There are a lot of nuances to this issue, so we're going to talk about them. And tonight I'm going to talk, and we've got Kingmaker. Hopefully, we're going to have Ship here soon. And we've also got my husband, Steve Gordon, as one of the speakers. He, as I think anybody who follows me knows, is also a lawyer, has been practicing law basically 50 years. He was a federal prosecutor for 10 years and has been in private practice since then. He clerked for the 10th Circuit. He's argued twice in the Supreme Court, so he's got the relevant experience. Okay, Ship just texted me and said he needs 5 more minutes, so and then he'll be joining us.
Leslie,
Yeah, King, go ahead.
we're getting message after message of people either can't hear or you're cutting in and out.
Not sure what to make of that. Okay. Well, my phone is charged up and my connection is good. I hear you guys clearly. So sometimes it works better with my headset on rather than me just talking into the phone. So let me put you guys on hold for 1 second while we're waiting for Ship anyway, and I will go get my other headset and see if that improves it. So hold on. Let me know, does that, is the audio better? It sounded fine to me the whole time, so I'm not sure what people were experiencing. Ship, are you in now?
I'm hearing you now.
Okay, great. All right, wave at me, folks. Manny, I see you there. Wave at me. Let me know. Can people hear me now? People are like, music, really? Yeah, that's something that comes with the thing. I'm not setting that up. That music is, well, they give you a couple of choices about what kind of music you want to have, but having music, not having any, doesn't seem to be a choice. So, okay, it looks like people are giving me the thumbs up now, so it looks like this connection is better. Yeah, so it seems like the problem was Twitter/X. All right, folks. So to start again, we are going to be talking tonight about. Some people are saying it's still cutting out. I'm not sure what to do about that because it's not for me on my side, and I'm not sure there's anything I can do about it. So King, does it still seem like cutting out to you?
No, it's fine.
Yeah, it sounds fine to me too. Okay. Continue to give us feedback, folks, about whether you can hear or whether you can't hear or whether it's cutting out. No, people are saying still cutting out. I don't understand that at all.
I'd suggest they sign out and then come back again.
Okay. Right. It does seem to have improved when I restarted it. But yeah, if it's cutting out for you, it could be that X has got a bunch of stuff going on tonight. It could be your connection, but it doesn't seem like from any of the speakers, it doesn't seem like the problem is something that we can deal with or correct in any way. Sorry about that. I will, if that happens, if it happens the whole time, I'll talk to the Twitter people tomorrow if I can get someone, an actual person, and I'll do some research on it to see if there's anything that the host can do about that. Okay, so what we're going to be talking about tonight is this Fisher case, and the case is going to be argued on Tuesday in the Supreme Court. And as I was saying before we switched over, we've got 4 lawyers on the call tonight, the usual suspects. So it's me and Shipwreck and Kingmaker, and also tonight on his own account. Now he's not sitting here with me; he's in the other room talking on his account. Is my husband Steve, who's also a lawyer and was a federal prosecutor for 10 years and has argued in the Supreme Court and has been practicing law for 50 years. So he's got a lot of experience to bring to bear to the issues at hand. So, first things first, we're only going to talk about Fisher tonight. We're not going to have enough time to address what's going on with Trump's New York case. We may do that later on this week, but we're not going to do it tonight. We just don't have time. There's just so many things going on in these cases for the former president. There's just not enough hours in the day to cover them all. So first of all, I'm going to spend just a few minutes talking about what the case is about generally, and then we're going to deep dive into all the various legal issues, of which there are many. Hopefully everyone has had a chance, if you wanted to look at the materials that I provided that were linked to the earlier spaces one, which I posted a bunch of stuff there. So the docket for the case in the Supreme Court, which has the briefs if you want to read those. It's got briefs for all the amicus groups that filed. There were various people that filed, most of them in favor or on behalf of the defendant, Fisher. The case is spelled Fischer, so it's not Fisher like fishermen. It's Fisher like this guy's, formal last name, Fischer. And there were a couple of briefs, 2 briefs filed basically after the government filed its briefs that were more or less in support of the government's position. So most of the amicus looks to me like they're favoring the position of the defense. And so there's a number of issues raised, but we just are not going to have time to cover anything else. So the first thing to know about this case is that it is one of the J6 cases. The DOJ is applying to the J6 situation the federal obstruction statute, which is 18 U.S.C. 1512. That statute in various forms has been on the books for a long time. And basically, it's the kind of statute that over time, the Congress has moved it around, but they have also added to it. They keep adding things to it because what happens is people think of new and different ways to obstruct investigations and obstruct their court case or their adjudicatory hearing or whatever it is. And so the Congress has to come along and add new thou shalt not do XYZ provisions to this statute because the human animal likes to come up with new ways to do things. And if 2 or 3 things are prohibited, then they'll find a different way to do it and try to achieve the same purpose. And so this is one of those statutes that you sometimes see in criminal law where it gets added onto over time as more creative ways are developed because the human being wants to, achieve its ends. And if certain ways are off limits, then people will come up with ways to try to go around those limits. So, but in The federal cases previously, no case had been brought of this kind against anyone ever prior to January 6th. This was a point that even the courts, the lower courts, made, that this federal obstruction statute had never been applied in this way before. And as we all know, of course, people have long protested at the Capitol. And in some instances, including some relatively recent high profile examples, people have protested the actual voting on the floor of the Senate. They protested, of course, during Justice Kavanaugh's voting for his nomination to be a Supreme Court justice. People have protested in the committee rooms and hearing rooms and so forth, interrupting the proceedings. The proceedings have to be stopped, and then security comes along, drags people off. That has taken place for a long time. Probably going back to the beginning of the Republic, people have tried to sort of, temporarily interrupt whatever the Congress is doing to say what it is that they want to say. But until these January 6th prosecutions, the federal government had never prosecuted those as obstructions. They prosecuted them under other sections, most of which are misdemeanors. In fact, all of them might be misdemeanors, as long as there was no like assaultive conduct. And basically it was for protesting. Protesting is legal, of course, but people sometimes get confused that protesting on public property is legal and protected by the First Amendment, but certain things cross the line from merely protesting, into illegal conduct. That's why we call it civil disobedience, because the disobedience part is an acknowledgement that, depending upon what the conduct is, of course, you may be breaking the law by lodging your protest. And because we live in a tolerant, open society, historically, we have said, okay, well, certain kinds of things that technically break the law, but really are in the nature of a temporary protest that maybe inconveniences people, but isn't, bringing down the republic, that we're going to tolerate those things. But nevertheless, they are illegal, and so people get arrested for them. So the people who protested in the Senate gallery, shouting while the Senate was voting on Kavanaugh's nomination to the Supreme Court, they were in fact arrested. They got hauled off and arrested, but they were charged with misdemeanors, which were not processed in federal court. They were processed in the local DC courts, and basically they paid some money, they paid a small fine, and their case never even actually was fully put through the court process. So that has always been going on, but not in the way that DOJ is prosecuting these cases. And there have been Bill, Ship, you are going to be able to talk about this, and Steve too, that, there's a pattern sort of in the federal courts in the last 10, 15 years, maybe even a little bit longer, of the government prosecuting things using novel or extended interpretations of a federal statute, and the Supreme Court comes along later and cuts that back and says, no, this is an overreach by the Department of Justice. And so the question in this case, big picture, is that what's happening here? Is the DOJ overreaching, overextending the obstruction statute by applying it to the January 6th scenario in a circumstance where they've never really done it that way before? And one of the good arguments that we're going to hear on Tuesday is that this statute doesn't really apply in multiple ways to this kind of conduct. Now, the reason, and Ship's going to be able to talk to us about this, the reason that the DOJ is doing that is because the consequences of a conviction or a plea to this statute are much more serious than what the government could get as consequences on the misdemeanors that they would typically use and that they have in the past used. Even if they did bring the cases, which they sometimes did in federal court as misdemeanors, the consequences here are much greater on this felony charge. So, Ship, you want to start with that and give people a flavor for, like, what's the difference? I know you handled cases where this is one of the issues. What's the difference between the misdemeanor versions and to get a conviction or plead to this a felony obstruction?
Well, there's two sets of misdemeanor charges that have been widely applied to pretty much every defendant that's been charged to date, whether they're charged with the felonies or not. The same basic 4 misdemeanors, and now and then there's an odd fact that introduces another provision of 1752. We'll get to that in a minute. But the nature of the conduct criminalized by the 2 sets of misdemeanors, and let me explain that real quick. There's a set of misdemeanor charges that have to do with the Capitol building and grounds being what is called restricted on January 6th. There's another set of misdemeanor charges that have to do with just unauthorized activity inside the building. Now, the unauthorized activity inside the building does not turn on how you got into the building. It simply turns on your conduct inside the building. This is the famous charge we hear all about parading. Well, it's parading, protesting, or demonstrating. But the parading seems to be the word that everybody has seized upon as kind of an odd characterization of criminal conduct. But it's parading, protesting, or demonstrating inside the building. And it doesn't matter how you get in. If you parade, protest, or demonstrate inside the building, that's a misdemeanor. It's a B misdemeanor, punishable by up to 6 months in custody. The second set of misdemeanors, as I mentioned, have to do with the nature of the Capitol grounds and building that day, that they were restricted. Well, they're restricted only by virtue of the fact that the vice president was either expected or was on the premises at a given time of day. The definition of a restricted building or grounds is not limited to the Capitol. It is any location where a Secret Service protectee is either present or expected. It's when the location is under the control of the Secret Service because of who's there. That location becomes restricted, and you cannot have unauthorized entrance into a restricted area. And on the 6th, that on January 6th, that included both the locations outside and the locations inside the building. So those are misdemeanors. The parading, demonstrating, protesting inside is a B misdemeanor, punishable up to 6 months. The incursion into restricted areas, unauthorized presence in restricted areas, is an A misdemeanor, punishable by up to 1 year. Absent those 2 counts, there was no other felony. Well, there is, but the government did not use it too extensively to start. There's no other really serious felony just for having been there and participating in the protest/riot if you did not have any confrontation or physical altercation with the police. That's a whole other set of felonies that we set aside, because that's kind of a unique set of factual circumstances involving a small subset, 150 or 200, however the count is, individuals who actually were, caught on video engaged in violent activity directed at police officers. That's a different charge that we're really not concerned with now. The 2 felonies that have been typically charged having to do with just felonious presence at the Capitol are a count called civil disorder, which is essentially a failure to respond to a lawful law enforcement command during a period of civil disorder, which is defined as a riot of 3 or more people. So 3 people get together, and if it's, if their conduct interferes with interstate commerce, 3 or more people, then that's considered a civil disorder as defined in the statute. And if a police officer directs you to leave and you don't do so, you've now violated that statute. That's a little bit of a
So if you're going to
glossy
do civil
overview.
disorder, folks, just do 2 people. Just
Yeah,
take
2
just
people,
take one other person. Don't
or
take 2.
don't interfere with interstate commerce. Now, just to show now as an explanation for most people here who don't know what I'm talking about, a lot of federal criminal law is tied to the Commerce Clause of the Constitution, because the general police power is vested in the states, not the federal government. But because the federal government has authority over interstate commerce, many federal crimes are connected to the fact that the crime itself has some impact on interstate commerce. The Supreme Court has said that impact need only be de minimis, and we don't need to go down that rabbit hole. I've had to go down it in the past many times. But that's the jurisdictional hook, so to speak. That the effect on interstate commerce is what gives the federal court jurisdiction, or gives the Congress the ability to write a criminal statute that can then be prosecuted within the jurisdiction of the federal court. And so the civil disorder count, a riot of 3 or more people having an effect on interstate commerce, creates a federal crime. It's a felony. However, it's a felony that has a statutory maximum of only 5 years, and it has a typical guideline provision that works out to 0 to 6 months. So it is the least significant of pretty much all federal felonies. There's not much bang for the buck other than the defendant ends up with a felony, but it doesn't carry much jail time, which then leads us to the only remaining felony where there's no physical confrontation or violence with the police, and that's the 1512 C2 count, which is the subject of the Fisher case. That is punishable by up to 20 years, and until recently, the typical guideline calculation without any significant aggravating facts, the typical guideline calculation would work out to 41 to 51 months for somebody with no criminal history. So there you had a federal statute punishable by up to 20 years, a felony, for which the typical sentence was going to be in the range of 3.5 to 4.5 years, which that became basically the go-to hammer the defendant's count when there wasn't violence directed at the police involved.
Right. Okay. So that's a good overview of like the difference between the two scenarios. One
I
where
have a question for Ship.
Okay, but let me talk first, King, about the audio, because that's where I was going to go, and then we'll do your question. So, all right, folks, I have tagged the Space Bugs people to see if they can help with the audio. I have also made Steve a co-host. Various folks told me before and have said now that sometimes making someone else a co-host somehow fixes the audio problem. Keep letting me know if you're continuing to have the audio problem. I'm gonna, as we go along here, I'll tweet at X and see if there's anything they can do about it. If you really just can't tolerate the cutting out, which I think will be solved on the recording, because it's not cutting out for those of us who are actually talking. I think that's a transmission problem, not a recording problem. Then, and you just don't want to sit through that, then end the spaces now, but tell Twitter / X, whatever, that you had a problem with the audio and that there was a lot of cutting out. And hopefully if a bunch of us do that, that we'll get some attention from them. And then tomorrow, as I always do, I'm going to repost the recording, which, as I said, I think is not going to have those cutting out problems. So we're going to continue to go ahead and do the spaces just as if there is no problem, and then we'll deal with the audio issues as we can. All right, so King, so what's your question?
Ship, what factors distinguished primarily between persons who were charged with parading and protesting versus those who got hit with 15C2 obstructing?
Well, that's a very interesting question, as now I have, been involved in more than 50 cases on the behalf of 50 different clients, and having looked closely at a couple hundred more. The dividing line, because pretty much anybody that went inside the building could conceivably be charged with having corruptly obstructed the proceeding, because the government's had two theories: either part of the initial crowd that breached the building, forcing Congress to adjourn and go into recess, that obstructed the proceeding. But then they expanded their argument dramatically for people who came in a half hour or even hour, or like Fisher, I think, came in an hour after the proceedings had been suspended. I think he came in at 3:24 or maybe 3:34. One of those two, 3:24, 3:34. And the proceedings were suspended at roughly 2:15. So in order to sweep up more people into the felony, the government's theory, which the courts accepted, was being inside the building while the proceedings were suspended was obstruction in the sense that the proceedings could not resume until the building was cleared and inspected and was deemed safe. So even if you came along and entered the building after the proceedings had been after the joint session had been suspended, you could still be charged with corruptly obstructing the proceeding because it could not resume while you were in the building. Where the government has found most of the evidence for the mens rea, the guilty mind, the intent to interrupt the proceedings, is social media and text messaging and emails. They have combed through the history of the defendants with grand jury subpoenas and outright search warrants, depending on what material they're looking for, and constructed or reconstructed the exchanges or commentary between the defendant and whoever else. So, just as an example, in the Oathkeeper case, where I was involved in 2 trials, Stuart Rhodes's phone was seized, and he had the Signal app, the Signal encrypted messaging app on his phone, but he had never deleted anything, so all of his Signal messages were on his phone. He had over 1,100 chats with 400,000 unique messages either to or from him. A huge percentage of which had to do with the election, the outcome of the election, the aftermath of the election, the contest of the election, and the events leading up to January 6th. So, but they found this in, I have a client where about everything that they found for a particular client were communications between him, 2 of his brothers, and a close friend. He wasn't publishing stuff to the general public. It wasn't on Twitter. He wasn't advocating for a violent overthrow or storming of the Capitol. It was just conversations between his 2 brothers, which was a big point in the trial. It's like, but the government's point of view was that still is evidence of his state of mind when he went there on that day, and then he acted on that state of mind. So it demonstrated that that was his motive and his intention for going, which was to interfere with the process set to happen.
So it's not limited to people who, in their social media, expressed a view that they intended to stop Congress from doing something. It was a political viewpoint they were expressing, and if you expressed the wrong political viewpoint, you got the felony. Is that right?
Yeah, from DOJ's standpoint, they have used it that expansively. They have, in my view, well, it's hard for me to say because I don't know what cases where they chose not, because we don't know the cases they didn't, where they chose to not file the 1512. We don't know exactly where the dividing line is. We only know the things they found on one side of the dividing line, the side they charged, not the things they found on the other side of the dividing line where they didn't charge. So, but it is all political wrong speak or political wrong think, to phrase it in that way. But a very interesting case I just tried, and we're going to get a verdict on May 1st, where what the government pointed to, and this is a bench trial, we're going to get the verdict, and I'm cautiously optimistic. The language of the government was pointing to my client could get on the stand, which he did, and say, I was advocating for the Eastman plan, which was the 10-day pause so that audits could be conducted in 5 states. So his argument was, I wasn't saying I wanted to interfere and stop Congress. I wanted Congress to act. I just wanted them to do what I thought they should do. And that case is both Judge Amy Berman Jackson. She seized on that in questioning. It was a bench trial, so she asked questions during the closing argument, and she really hammered the government on that issue. Where's that line? Advocating one outcome over the other, as opposed to simply trying to stop Congress altogether. Now, there's plenty of commentary by people about wanting to stop Congress altogether. You have lots of incendiary, overblown, hyperbolic, rhetorical excess in the communications. I mean, we've all seen it, so there's a lot of it on the side of the line that the government has relied upon, but the government seems to be using a meat cleaver instead of a scalpel and trying to decide, what might be an appropriate effort to truly target people who were there for the express purpose of interrupting the proceedings, as opposed to people who were just unhappy and protesting in an unacceptable fashion.
Can I weigh in for a minute here?
Sure.
Chip's point brings up a point that you and I have discussed prior to starting tonight, Leslie, which is that this obstruction applies to all three branches of the government. It applies to the judicial, to the legislative, and to the executive branch. And when you're talking about the judicial branch, which is typically what people think about when you talk about obstruction of justice, you're not permitted as an outsider to lobby a judge or a jury. They make their decisions based on the evidence and only the evidence. And it's improper to try to put in other influences. But when you start talking about the legislature, which is what we're talking about here, that doesn't apply. And in fact, people have a constitutional right to lobby the legislature to act in the way they think it ought to act. And so you're applying a criminal sanction, which is correctly says is a meat cleaver, in a situation where people have a constitutional right to protest, or at least to lobby. In terms of the protest, we get into the civil disobedience that Leslie talked about earlier. You have a right to lobby Congress. You don't have a right to stand up in the middle of the vote and start screaming and carrying on and pitching a fit, trying to interrupt the vote. Now, you can do that saying, well, it's a form of civil disobedience and protest, but then you subject yourself to potential criminal penalty. The problem here, and it's been discussed before, but it forms the backdrop of all of this, is that there's a history here where for years and years and years, where protesters have come and done that sort of protest, they have been treated very leniently by federal officials under both Republican and Democratic administrations. But here, that completely changed. And when they started deciding how to approach, when the Department of Justice decided how to approach these cases, it looked around for heavy-duty charges it could throw at these people. And the heaviest duty charge it could throw at a lot of these people is the charge we're talking about now, the 1512C, which was a new and unprecedented use of this statute.
Right. So we know why that is, right? Ship's explained basically that it allows the government to ratchet up the seriousness of the case, which gives the government a lot of advantages in a criminal case. It helps them when you're trying to wring a plea out of a defendant. It certainly helps with the jury. Definitely helps with the sentencing if you can get convictions either through a plea or through the jury. You get longer sentences when the charges are more serious. So the reason the government, I think, wanted to use this statute, which they initially did not at the very, very beginning of these J6 prosecutions, they were using the misdemeanors. Now, they would probably say, well, we were going for the low-hanging fruit, people who didn't engage in very much bad conduct, blah, blah, blah. We were just getting started, so on and so forth. But I really think that the reason the government transitioned to this statute is because the district court judges were initially giving sentences to people who pled guilty at the beginning to the other charges for basically the same kind of conduct, none of which at that point was assaulting officers, really. The district court judges were giving reasonable sentences that were in line with, they were maybe a little heavier, but not substantially heavier than what people in past protest situations would get, or people charged with other kind of similarly low-level offenses in our federal court. But once those judges started giving sort of low, from the government's point of view, low sentences, then we saw this shift to this statute. And so one of the reasons that this argument in front of the Supreme Court is going to focus on this has never been done before and why is the government using this statute? The reason is because they're trying to shoehorn a scenario into this statute because there weren't any others that carried these kinds of penalties. 18 U.S. 1512 is a 20-year maximum, potentially, felony statute, and they didn't have that kind of ammunition with any of the other statutes. So that is really why it's going on, but it also informs why the arguments are so strained, I think, on the government's side of the coin. So let's turn then to the actual arguments on the statute. And King, I want to bring you in on that first. And then we are going to cover, just so people know, because Steve and I were looking at this today, the retroactivity issue. I know that's a question that people have had, which is this, let's say the Supreme Court does reverse in Fisher. Let's say they do say that there's the statute does not apply and that these folks should not have been charged under it. What happens to the people who've already pled guilty? What happens to the people who were already been to trial or are waiting going to trial? So we are going to cover that issue a little later on. Okay, so King, let me ask you, have you had a chance to read the briefs?
I have, and
Okay.
I think I can boil it down in
Please do.
relatively simple terms with some help from a childhood hero of mine.
Yeah. Okay, go for it.
But before I get there, let me outline what the statute says and where this novel construction the government is using comes from. We're talking about it's 1512C2, but 15C is one sentence, and I'll read it. Whoever corruptly, 1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. That's subpart 1. Or subpart 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined and imprisoned, etc. It's the otherwise clause. Otherwise obstructs, influences, or impedes. In the simplest terms, the government says otherwise obstructs, influences, or impedes means anything the mind could conceive of that would obstruct or influence or impede an official proceeding, so long as it's done corruptly. The defense, the Fisher side in the Supreme Court says that is infinitely broad. Congress could not have meant that. What they clearly meant instead was that the otherwise clause is a subset of number 1. Number 1 refers to ways to mess up the proceeding by tearing up documents, destroying documents, mutilating them, concealing them, thereby impeding the fair, in the integrity, the use of evidence, the consideration of evidence. And the otherwise clause is, well, if we didn't list it in subsection 1, some way of destroying evidence, if you can, we can't think of every possible way to do it, so we'll have a catch-all to cover other ways to impede or impair the proceeding by messing with the evidence. It doesn't mean all other ways possible to obstruct, influence, or impede. That's just way too broad. That's the
Okay, so
two sides of
that's the two sides of it. So let me take a poll amongst the four of us. Do we all agree that if the Congress wrote a new statute that just says whoever corruptly impedes, influences, obstructs a congressional proceeding of any kind is guilty of a felony? Do we all agree that a statute that was that broad is unconstitutional?
I vote yes.
All right, Ship, your vote?
Yes, because there's no limiting principle, so there's no notice to the public as to what might be covered.
Okay, Steve, you agree?
Yes.
Okay, so everyone understands this. This is the way criminal lawyers look at it, both prosecutors and defendants, because there are limits on what the Congress can say is criminal. This is a solid concept in the criminal law. The Congress cannot write statutes that criminalize conduct that are so broad, so vague, so all-encompassing that the average person can't figure out what's allowed and what's not allowed. Now, in objective reality, do the American people have the ability to understand most of the criminal statutes? I mean, not really, right? But a lot of the ideas in the criminal law, especially ideas that center on due process and fairness, are based on old common law concepts, and this is one of them. That in general, the law should be simple enough, or at least clear enough, so that people can understand what's prohibited and what's not. And there are lots and lots and lots of cases over the last 2.5 centuries where the Supreme Court and the lower courts have struck down statutes that are criminal statutes because they are overbroad or vague or too ambiguous, and they say this violates due process because you can't figure out what you're allowed to do and what you're not allowed to do. So no one in this case, this is what's intriguing me today, no one in this case, either side, including the government, is arguing that this statute, if you just literally took that section, it said you can't impede, you can't obstruct a criminal proceeding, a official proceeding, no one would take the position that that standing alone was constitutional, because the Supreme Court would certainly say that it is not. So the struggle in this case for the lawyers, the judges trying to apply this statute, is pretty much that's what subsection C2 says. And therefore, how can they, as judges, construe this statute, interpret this statute in a way that makes it constitutional when fundamentally there's kind of a problem with this section that it's not very constitutional? And so the lower court, the Court of Appeals in D.C., Circuit Court of Appeals, the three judges, they couldn't decide on what the correct interpretation of this statute is. So before we got to the Supreme Court here, one judge said this statute doesn't apply to this conduct because this statute only applies to evidence. Basically, he agreed with the trial judge who threw this case out again for this particular defendant. The other two judges couldn't agree on what mechanism to use to make this very broad language, make it constitutional. And they alighted on the theory that, well, we're going to say that calling it corrupt conduct narrows the statute enough so that people know what it is that they're not supposed to do. And then they had a debate about whether or not what that meant, what the level of corrupt meant, whether that satisfied the problem or not. And so the lower circuit court opinion is kind of all over the place. B, the three judges, none of them agree on what the real reasoning or answer in the case is. And so that opinion is not helping the Supreme Court very much, if at all. To be honest, that opinion is, I think, the worst appellate decision I've ever read in my entire career as a lawyer. It's absurd, that opinion. And what happened was that got sent back down to the trial court to figure this out, and none of the district court judges can really apply it correctly. And so now it's come back up, and we're going to hear what the Supreme Court thinks about this. But one way of looking at this case, I'll be interested to see if the Supremes ask any questions about this, is maybe this section is just the Congress trying to write a subsection of this statute that is unconstitutional. Now, the Congress wouldn't say, oh, we're going to write an unconstitutional section, but they have in the past written sections that are unconstitutional, and the courts strike them down. So it may be that what the Congress was trying to do is exactly what they're not allowed to do, which is write a section that's so broad that, as King was just saying, that it kind of covers the whole field of whatever, machinations or crazy kinds of scenarios that the human brain can come up with. The Congress doesn't want to write a laundry list of 500 different ways that you can engage in obstruction, and they're just writing this broad brush. You can't obstruct. Okay, that would be unconstitutional, and no one would disagree with that in the courts. So instead, what we find is this struggle between the government trying to salvage this section and say it's not unconstitutional, and the defense, which is represented in the Supreme Court by the federal public defender. Their brief is excellent. I would recommend, if you're a lawyer, go and read that brief. They are making a ton of statutory interpretation arguments about this statute cannot be constitutional, can't be correctly applied and interpreted based on all these rules that lawyers and judges use to try to understand what the statutes mean. Lawyers call those the canons of construction.
Can I say something here?
Yes, go ahead.
This is where I started my analysis,
right.
Is to figure out how to explain to a layperson these arcane lawyer rules,
half of
and
which are in Latin.
I'm not even going to talk Latin.
You're not going to use your Southern accent on the Latin, because that would be beautiful.
I'm not going to get there. I'm not going there. But I am going somewhere else. Like my childhood hero had something to say on this, and we can put instead of our legal caps on, we can put our baseball caps on. I'm speaking of Yogi Berra. One of his famous sayings uses the word otherwise, and it presents a similar equivalent dilemma. What did he mean when he said we should always go to other people's funerals? Otherwise, they won't come to yours.
Right.
So, picture, if you would, a big room full of Harvard lawyers trying to parse through that sentence with the
trying
otherwise.
To parse through Yogi Berra's sentence.
That's it.
Right.
And we get piles of dictionaries. They look at word by word. They define each word. They figure out how otherwise is used. Is it used to narrow what came before it, or is it used as a conjunctive, word to add to what was said before, or is it disjunctive? And then we'll diagram it grammatically. And if you do all that, you could come to this. What he meant was, don't go to somebody. Make sure you go to everybody's funeral that you know, because if you don't go to their funeral, that person who's been put in the ground, when you die, he won't come to yours, which is an absurdity. But that's kind of the way the government is tearing apart the grammar and the use of the word otherwise that Congress has here, because they can find cases that say otherwise is expansive. It means anything else other than what we said just before. So anything else means anything imaginable. All kinds of things you can do to obstruct, influence, or impede.
Right, but don't you think they come perilously close in their argument to
I'm
therefore saying that
oh
the
yes,
statute
indeed they
reaches
are.
so far
It,
that it would definitely be unconstitutional, right?
but the other side points out that there are other cases that say otherwise doesn't always mean that. Otherwise can mean something limited, something uh, a limitation that is tying the things that you describe after the word otherwise, a limitation that ties back to what came before. So it's a subset of what came back before.
And
Just
I think we do that in normal English speech, right? Like we
and,
use that word otherwise both ways.
and we do. You can use it either way. That's the point. Grammatically and through by the dictionary, you can use it either way. And how do we know what Congress meant? Well, I'll go back to Yogi Berra. The one way to look at it, you come up with an absurdity. He's telling you to go to somebody's funeral so that person can go to yours. Another way to look at it is he was New York. He was New York Catholic, uh, you know, Italian, went to funerals all the time, and it's a social event. It's a celebration of a person's life. The funeral is not the person going in the ground, the funeral is the people that go to it. And it's those people who won't go to your funeral if you don't show up where they are grieving for somebody, one of their friends or family members. That's what he meant. And that's clearly what he meant. And so you to get to Congress's intent, you have to look at these other issues. Did they really mean to broaden the scope of what is criminal that far as the government wants to push it?
Right. So let's talk for a minute about. Thank you, King, for that overview, like what the statutory problems are. Because unlike a lot of cases, you guys, where the question is something constitutional, right? Are there constitutional rights at issue, especially in criminal cases? This case is a grammar case. It turns on syntax, grammar, word choice, punctuation, even potentially. The brief for the federal public defender cites a case from Justice O'Connor where she's talking about how punctuation is like a really thin reed to to try to hang your hat on, right? But these are the things lawyers have to resort to when you're trying to understand what does a statute mean, and a court has to apply that statute. What are they supposed to do? They can't call up the Congress that passed this back in the day in the Sarbanes-Oxley Act time and ask them all, well, what did you mean by that? Right? So let's talk for a minute. Steve, do you want to talk about this? About why did this section get added to the statute to start with? Do you want to do that, or you want Ship to do that?
Let's let Chip do it.
Okay, Ship. So help folks understand who don't know, like why is this section even in this statute? Because most of this statute is about you're not allowed to intimidate other people, kill witnesses. You're not allowed to intimidate other people into destroying evidence, etc. That was always the obstruction, statute, the way it read, going back way, way back, decades, maybe 100 years.
Well, the problem that arose out of Enron was that the statute prohibited you from having third parties do things on your behalf. It didn't prohibit you from doing those things yourself. There was no first person liability. So I think I've got that right, or is it the reverse?
No, you got it right. Like
Yeah,
you
yeah.
couldn't intimidate someone or bribe someone into destroying documents for you.
Exactly. Yeah. Intimidate witnesses into giving contrary testimony than what they might have otherwise given. But there wasn't a prohibition against doing that yourself. So giving the misleading or whatever the case might be. So this one addition to this obstruction statute was meant to be broad. It was meant to criminalize first party conduct. In other words, you can, or otherwise, meaning the actor corruptly interfering, obstructing,
Their own case or their
yeah,
own
yeah,
investigation.
exactly. Um, what I throughout 30 plus years of doing this kind of work and looking at these kind of issues when they arise on appellate, the thought that always goes through my head is I I refuse to believe that 3 congressional staffers sitting in a drafting room are agonizing over this language in the same
Right.
degree that judges agonize over this language trying to figure out what they meant. We know
Right.
it's not the congressman sitting in the drafting room writing
Right.
this stuff. It's their
Literally the
staff.
words.
And,
Right.
and there is no way that they spend this much time trying to be this exacting and this precise and considering the things that the court then comes along later and says, well, we've got to try to decipher what it was they were thinking about.
Right.
I
Now, the
mean,
court doesn't have a lot of choice. They have to
well,
apply the statute. They have
right,
to
right,
figure it out. Yeah.
yeah,
Right.
but it's just like,
But it's a bit of a fiction.
yeah,
Yeah.
Yeah. Can I jump in
yeah,
here?
Yeah.
go ahead, Steve.
So, what this raises to me, well, what you've got going on here in terms of trying to determine it, you've got different arguments that are being made. And I think that there are basically, if you will, 3 levels of arguments that are made in the brief. One, as has been pointed out, is the very, your English teacher would love this, the syntax, the punctuation, the this, the that, very down in the weeds. You couldn't get more down in the weeds
Then punctuation.
than what they're, but seriously, if you
Yeah.
read these briefs, that's exactly what's going on. So that's one level. But there are other levels, there are other legal rules of construction that are being advanced here that are at a little bit higher elevation.
Now, are you
And
going to try to handle the Latin? Because you guys, Steve went to Swarthmore College, so he's got a classical type education. Are you going to endeavor the
no,
Latin?
so the 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 higher level is to sort of look at Congress's purpose and look more generally at the context of the statute. And here, as has been discussed before, this is a statute. The 1512 is a statute that's been around a long time, and it talks about various different forms of obstructing proceedings. And we're talking about one section and an amendment to add to it.
Hey, Steve, let me interrupt you just for a second because I want to add one thing to the point you're making. 1512 is one of 21 obstruction statutes
Right.
under Section 1500. So it's
Yes,
not like it's just 1512 or just 1512C. There's literally dozens and dozens of subchapters in
there's
those
about
21.
there's about 20. There's about 20 provisions if you go to that part of the U.S. Code. So I agree with you. And if you look at the history, and this has been touched on earlier, the history of this particular addition to the statute is that it was designed to solve what had happened in Enron, where people who had destroyed their own documents couldn't be held to have obstructed justice because the statute didn't apply. And Congress decided to fix that. Well, so the history is pretty clear. I shouldn't say pretty clear. The history is very clear that the problem that Congress was attempting to address is not what we're talking about now. It wasn't about people charging the Capitol or going through the Capitol halls. It had nothing to do with that at all. So that's the second level of analysis. The third level of analysis is this, and that is generally, when a court is interpreting a statute, if it is a criminal statute, because the penalties for criminal conduct are severe, and we are very cautious about how we apply them, you've got what's called the rule of lenity, and it's common sense provision, which says you, given a choice between construing a criminal statute broadly or narrowly, you'll construe it narrowly because you don't want to sweep in to the criminal sanctions people that may unknowingly be doing something that they thought was okay. So here, the government focuses almost entirely on the syntax because that's the only argument that they've got that really works for them. If you start looking at the bigger picture arguments in terms of what was the purpose of this particular amendment to the statute and what's the general rule of construction of criminal statutes, those both work in favor of Fisher and the January 6th defendants who say, hey, this is not what Congress was going after, and to construe it this way violates these rules of construction that the courts have had for a long time.
Can I add something? Leslie? Can you hear me?
Well, I'll let you add something, King.
Okay. That's right, and there's an amicus brief authored by Jay Sekulow and his team that raises a First Amendment constitutional argument over everything. Basically, they argue that, broadly speaking, obstruction and particularly influence, corruptly influencing an official proceeding, can mean anything. It can mean filing a brief. It can mean filing a lawsuit. It can't, if it's done, quote, corruptly. And if to construe this statute as broadly as the government proposes would have a chilling effect on the First Amendment.
Well, this was my point, is that the parties are not making that argument. But to me, as a defense lawyer, that's an argument, an obvious argument. The Congress cannot write a statute that is that broad. To do so is unconstitutional. So that's literally what this subsection says. If you viewed that section in isolation and got rid of the rest of the statute, even adding corruptly in front of it doesn't make this a constitutional statute. It's not. It's unconstitutional.
The point as to the adding corruptly part, and I think this is an excellent argument. They say if you file something that the government doesn't like in a court case, for example, or in Congress, for example, guilt or innocence turns on whether you had a corrupt intent when you did so, which devolves into an analysis of what was in your mind when you filed a petition, when you filed evidence, when you made an argument in any official proceeding.
Well, and it's like the problem that we have with quote unquote disinformation and misinformation nowadays, right? Who's deciding what that is? Who gets to decide that your motive was corrupt? Maybe your motive is just the dissenting view, right? So this is a very dangerous slope that we're on with this kind of argument.
Well, okay, except I have to jump in here and say that there's a long history in the criminal law of letting juries decide what your intent is. For example, in first degree murder, you have to have premeditation and deliberation, which is a state of mind, and we let juries decide whether you do or don't. And that's the difference between first and second degree murder. And there's any number of other examples within criminal law.
Yeah, but here you're talking about not killing someone, but whether or not the arguments that you're making, right, the evidence you want to put in, the spin you want to put on that evidence, the arguments that you're making about the case, whether those are right or wrong, good or bad. This is not, this is criminalizing people's views of things, not how much intent did you have when you killed the person.
Well, okay, so that comes back to the point I made earlier, which is it, if you're talking about trying to influence the judicial proceeding, we don't allow that because it's dependent on the evidence. But when you're talking about the legislature or the executive, people have an absolute constitutional right to lobby for their perspective, be it good, bad, or indifferent. So if we narrow it to the context of the legislative or the executive branch, then I absolutely agree with you.
Right. So I'm with you, King. I'll be fascinated to see, does the argument Tuesday, do they pick up any of the points that Jake Sekulow is making in his brief? Because he's arguing the broadest form of, this is just straight up no can do unconstitutional, this statute. Yeah.
Steve, I beg to differ. You assume that this is directed only to the parties of a proceeding, but it's not. It let's say you have a newspaper editorial writer, and we see this today, uh, expressing opinions for and against putting Trump in jail. Those are attempting to influence a proceeding. They're, if they could influence, they would.
The jury,
the jury and the judge. They're doing everything they could to gain influence over what happens in that proceeding. And the First Amendment gives people that right. And it's not, and Congress cannot call that obstruction or corruptly influencing without stepping over and onto the First Amendment, in my opinion.
Right, because as Ship always says, putting allegedly or wrongly or unlawfully or corruptly in front of XYZ conduct, that doesn't save it. In some circumstances, it does. We use corruptly a lot in statutes, right? You have to have a corrupt intent. But the problem is when you're talking about ideas, it's very different from actions. And this statute, the first part of it seems pretty clear, doesn't it? You can't alter or delete a document or a record. You can't mutilate an object. You can't take evidence and change it because that corrupts the judicial process. But when you then expand it the way the government wants to this idea of, oh, and you can't do anything else that corruptly interferes also, now, we're in bad land here, right? That could mean you can't be the editor and write an editorial about whatever the Congress is proposing to do in their hearing because you're corruptly suggesting ideas. This is very dangerous.
Well, where this is played out as being dangerous, in my view, in the courtrooms is the presumption that the government applies and that the courts concede to, that one set of views about the election was right,
correct,
and another set of views about the election was wrong.
Is wrong,
right? And if you're expressing the wrong views, and then you show up and do, something that is, a protest activity married to the wrong views, is therefore criminal.
Right, because they're deciding that that's
level,
enough to be corrupt.
Exactly. At the granular level, expressing that wrong think is just like you just said. That's the corrupt element, the wrong think that goes along with your action.
Right. So even though this case is, as we've been saying, it on one level, as Steve was saying, the nitty gritty of it is, all right, we're doing hardcore textual statutory analysis, right? Where's the comma? What does otherwise mean? Is that negative or positive? But bigger picture, the way the government is prosecuting this case, the arguments that they're making in the Supreme Court are really, really problematic, fundamentally dangerous, I think, in some ways, if the court were to adopt them. So, all right, let me
bring a different argument. The one that appeals to me the most as sort of a practitioner. And I think, I suspect this might appeal to Steve as well, based upon, the discussion we had recently. The, the government's use of the statute in this fashion, which in effect just basically throws open the barn door and says, anything that escapes the barn is, a possible
Right.
violation. We can't describe it all, so we'll just say,
You
whatever
can't leave the
happens,
barn. Right.
whatever
Whatever.
happens, and we don't like it, that's going to be a crime.
Right. Yeah.
The problem is, based upon various kinds of statutory analysis that we've done, many times through our careers, where that language swallows the rest of the obstruction statutes.
Right.
It just it basically it makes everything else unnecessary.
Not
If
just in this statute, but almost all
but
of
all
the
of
whole
those,
obstruction section in the code,
yeah,
which is an
yeah,
entire chapter.
and there's a basic canon of statutory construction that says you have to make the statutes work together.
Right. It has to make sense.
Yeah,
Yeah.
it has to fit with as part of the overall concept. And if you write something that's so broad that it swallows everything up, that can't be what Congress meant. Because if that Congress truly meant that, they would have just deleted everything else and had one section.
Right. You just don't. That's what I said. You could boil this whole statute down to this subsection. The problem is the government can't really go there because if they make that argument, it's so obvious that it's unconstitutional that they will lose and they know it. So instead, they're saying, well, it is narrow. And I'm looking at it thinking, but it's not. Your interpretation of it is not narrow. You saying that you're giving a narrow interpretation doesn't mean that's what's happening. So, well, Judge Nichols, in his opinion, analyzing this statute, quoted from an earlier case. Was it Judge Silberman's case? This idea about the elephant in the mouse hole. So there's an earlier case, and he used that language to try to explain the point that Ship is talking about, you guys, which is the government is saying, oh, this covers a huge amount of things potentially, but you've covered a huge amount of things in one subsection of a statute. Why would you do it that way? That doesn't make sense. So it's this funny analogy of, well, the Congress is not in the habit of hiding elephants in a mouse hole. I'll be interested to see if that proposition comes out in the argument on Tuesday. Well, what do we think overall? Let's go one by one. King, let's start with you. How do you see it turning out?
I don't see a majority of the court buying the government's position.
That's where I am too. Yeah.
I do not see that. To me, the bigger issue is how they write it, how they do they try to narrow the scope of subsection 2 in some rational way. That's what Jack Smith hopes they do, so that he
Can
has
still use it against Trump later, right?
he can still use it. By the way, his theory is, I don't need the Supreme Court to say to affirm all those convictions on the January 6th defendants. I have an evidence-related charge under 15C2, that being these so-called fake electors that were put up in Congress.
Because
Those
there was paperwork for that. Yeah.
Those papers were fraudulent, and therefore I can still use 15C2 to convict Trump for obstructing or corruptly trying to obstruct or influence Congress with fake electors. I say bullshit to that, but that's his hope.
Okay. All right. So let's go down the row here about what we think they're going to do, and then we can talk about, well, how are they going to do it? Okay. So, the overall outcome. Do you think the court says the statute does not apply in the way the government has been applying it?
Well, okay, I'll say this. It's always dangerous to play the game of why did the court take this case? Why did 4 justices vote? Typically, 4 don't vote unless they think they've got a 5th, possibly lined up.
All right, so people understand it only requires 4 justices to take the case, but 5 obviously to win. So if you're
Right.
on the court and and you have a certain view about an area of the law, but only 3 of your other colleagues agree with you, then even though 4 of you could force the court to take the case, you wouldn't do that because you're going to get outvoted on the actual outcome.
And so you're
Right.
just wasting time.
Right.
The court has it only takes a limited number of cases a year. It turns down thousands of cases that takes, something less than 100. So why did they take this case? I don't think, okay, it's a case of first impression. It's a case that will never be filed anywhere other than the District of Columbia because Congress is involved. You're not going to have an interfering with a congressional proceeding somewhere outside the District of Columbia. So it's only going to be the DC Circuit. If the court thought, and remember, what they're evaluating is the outcome of the case below. Is the outcome correct? If the court thought the outcome was correct, even if the fractured opinions were problematic, the view would have been, well, we'll let the DC Circuit smooth out the sharp edges on its fractured opinion in
As it
later
goes along.
decisions.
Yeah.
Okay, we'll let them sort out their own problem. We think they got the outcome right. They take the case to change the outcome. And it comes in a long line of similar cases, which we've talked about before. Since 2005, the court has taken 6 federal criminal cases that involve some form of obstructive conduct. Every one of them had been affirmed in the appellate court. Every conviction had been affirmed, and all 6 were reversed by the Supreme Court. 4 of the 6 reversed unanimously by the Supreme Court. And every one of them involves sort of a novel, expansive application of federal criminal law in ways that the Supreme Court decided was not appropriate. So
Goes
it's
too
like,
far.
it's only the Supreme Court that really is the right forum to do this. And they've done it consistently where the opportunity has arisen and where the need to step in has arisen. And I think they took it here because they know if they don't take the first one, what's the benefit of taking the 10th one? If they're going to put a stop to this, they need to put a stop to it now. If they thought it was rightly decided, they would just let it go. So I
Right.
think that's the only reason. I think that's the only rationale that I can come up with, and I don't think 4 justices would have taken it if they didn't have a 5th vote.
Right. All right. So your view is they're going to reverse and say the statute does not apply this way.
Now,
Okay.
there's another little angle here that I think is
Well, wait a
maybe
minute. Wait a minute. Let me let Steve cast his vote, and then we're
okay.
going to talk about okay, but how are they going to do that? And we can talk about the little angles. Steve, your vote is you think they're going to reverse and say, yeah.
Yes.
All right. So basically, you guys, all 4 of us think that Fisher is going to come out for the defendant against the government. And now let's talk about, okay, so Ship, will start with you since you had a little angle. How are they going to
Yeah,
do that? What are they going to say?
there's another issue here. See, so the to the extent that there's a concern about, well, then you're just going to have these misdemeanors and you're just going to have this 0 to 6 month felony, under the guidelines. So, how does the court or how does the government express its unhappiness and disapproval of this sometimes violent and destructive conduct that went on by this group of 50,000 or however many people that were there? Well, the district court judges have now answered that question. They've said they're going to vary upward on the civil disorder count, which can go up to 60 months.
Right.
Even if the 1512 is tossed out, these judges have begun to give sentences that said, my sentence is 32 months, and that would be my sentence even if 1512 is tossed out, because I would simply vary upward because I think 32 months is the right number.
and they're going to vary upward, meaning giving more time on the civil disorder,
than the
which is
guidelines call for,
right.
because
Which
it's this is not just any other civil disorder. This isn't a riot in the streets of Tuscaloosa.
outside a bar for because of whatever, right? All right. Okay. So people understand the civil disorder is basically what the federal statutes call a riot. Okay. Um, and there are the misdemeanors, right? So for some people, maybe the government won't be able to prove civil disorder, right?
No, everybody's stuck with that.
You
I
think
mean,
so?
yeah, everybody that hung around and didn't respond to law enforcement directions to leave, that's just such low hanging fruit. There's just
Hmm.
no way to defend that count.
Right. Okay. All right. So now the former president is not charged with civil disorder, correct?
Correct.
Right. So they can't pull that trick on him unless they're going to amend, but I don't see Jack Smith amending to add civil disorder to Trump's case.
Well, no, I think what Jackson's going to
But
do, he's going to do exactly what King said. Is he's going to say, my theory has nothing to do
Yes.
with the violence. My theory has to do with evidence impairment or document impairment.
Right.
The problem now, and
Well,
and
wait,
and
we're
he
going to get to that. We're going to get to that, Ship, in a minute, because we need to talk about this official proceeding business, which is where that goes. And we've had some questions.
well, my point is it
Steve,
changes
what
his
were
case. He's not going to get into the evidence of violence then. All the evidence of what happened that day is irrelevant. If his theory is about false electors, then the evidence of the protest or the riot at the Capitol is all 403. It's irrelevant to the use of false documents. So it's a different case. He'd probably still wins it in front of a DC jury.
maybe he's still going to try to hold into those counts under this other
Right.
theory. So we talk about that in a second. Steve, what you were going to say?
well, you're veering off into Trump's case. I don't want to do that just yet. I want to pick up on what was being touched on earlier, which is this: if the Supreme Court reverses in this case, which we've all predicted is what's going to happen, what will be the impact on all of the people that have been convicted or have pled guilty?
Right. So Ship was talking about the effect on people who are still in the system. The government would just switch to something else. They'll just switch to the civil disorder. But yeah, you and I were working today on, okay, but what about the people who've already pled to the 1512 and been sentenced?
Right. Well,
Right. The judges,
right.
what are they going to do about that? Or people who went to trial or whatever. So yeah,
Well,
go ahead and explain that part.
the law draws a distinction. Anybody who has gone to trial and been convicted and where their appeal hasn't yet been decided uh, is clearly going to be able to raise this issue. And then, if their appeal has been decided, they fall into the realm of what lawyers call collateral attack. And there's a federal statute, it's called habeas corpus sometimes. There's a federal statute, 2254, that covers the same thing. So the point is that, and this is, you see this all the time, like in death row cases and stuff like that. The defendant, he's been convicted, he's been sentenced to death, he's had his appeal affirmed, and then he's raised collateral attacks. All right. So the issue is whether you could raise on collateral attack if you've pled guilty, not going to trial. You've pled guilty to the 1512 count because you're advised by your attorneys. Well, the government says this applies. All of the district judges in DC except one have said it does apply. So you're guilty. You might as well get it over with and plead to it. Can you now come back and attack your guilty plea? And the answer under the existing DC law is yes, you can. You can come back and attack your guilty plea and say, it now turns out that under a correct interpretation of the law, I wasn't guilty of a felony offense. Now, there is one limitation, and that is if you were charged with an even greater offense and the government let you plead to the 1512 as a lesser offense, in order to collaterally attack it, you'd have to show that you're not only innocent of the 1512 offense about which we've been talking, the obstruction offense, but also of the greater offense. There aren't going to be, as a factual matter, too many situations like that, and Ship would know that even better than I do. But you could raise it, and so if the Supreme Court reverses, which is what we predict, it will lead to a large number of defendants who have been convicted in the January 6 cases, either through trial or through plea, and the pleas are far more numerous than the trials. It will lead to them coming back before the judges and saying, wait a minute, we got to do over.
On the 1512, on the obstruction. So if they, to make it easier for people to understand, if the person has the obstruction and they only had misdemeanors, then through one mechanism or another, either on direct appeal or this collateral attack, which comes after your appeals, those folks are going to be able to come back to court and say, this is basically an unlawful sentence on me that I got. Whether they're serving or not serving, there will be mechanisms for doing this. And they'll be able to have the 1512 lifted off of them. That should result in some of them having their sentences reduced. Ship, aren't there a couple of people who have been released by the district court precisely because their sentences are such that if the Supreme Court reverses, then they will have overserved by the time the court makes that decision?
Yeah, this is a burgeoning area of controversy that has kind of percolated up in just the last couple of weeks, because two judges have denied release by saying that even if the 1512, just like I said earlier, if the 1512 was tossed out on other counts, the judges would vary upward to get to the same sentence. So they're not going to overserve even if the 1512 gets thrown out. Where I think more complications are going to come up is, well, let's use Jacob Chansley as an example. He pled guilty to a 1512 count, and he did 41 months. He's done. So you can't make the earth spin backwards. You can't get the time back, but he can get the felony expunged, and then he would only have misdemeanor offenses. Well, he didn't even plead to any of the misdemeanors. That's a question that I don't even know the answer. I've never had to confront it. Let's say a defendant is charged with 3 felonies, and the government allows him to plead guilty to one, and it's the 1512, which was the government's go-to. That's what they demanded the first 18 months. If you had felonies, you had to plead to the 1512. You couldn't plead to another
Now,
felony.
let me ask you this. Let me ask you this, because on this precise point, because Steve and I were doing this research today, the other charges that those folks had to, that the government dropped if they agreed to plead to the obstructions, were those other felonies more
No.
serious?
It's a
They
231,
were,
which is a 5-year maximum, and the 111A, which is
right?
the 8-year maximum. The only charge
Okay.
that would have been as serious would have been a 111B count, which has a 20-year maximum. That is where there's,
Mm-hmm.
the 111B count, which is assault on an officer. The B count is the aggravated form, and it comes into play if a dangerous weapon was used or bodily injury was suffered by the victim.
All right. So, Steve, you know this law better than
But,
I do because you read it more
well,
closely. But go ahead.
I've
Yeah.
read it because I've read it today. The DC Circuit has said that the relevant measure is not the maximum statutory penalty, it is the guidelines range. So if the other statutes under their sentencing guidelines range is lesser, then they're considered lesser. And
if they're lesser, Ship, then the case is called CASO, CASO. If all the other felonies were lesser, then this person is going to be able to get out from under that 1512 for
Well,
sure.
but why would you be stuck if you've never been adjudged guilty of the more serious crime? In other words,
you have to, because under 2255, you have to show actual innocence.
Yeah, it's
So there's
because of the
Mm-hmm.
cases,
procedural rules the court rely on collateral attack. That's why. It's messed up. It's like divorced from justice. So,
but the short answer is that if the other offenses that the government dropped were of equal or lesser significance under the guideline range, then you're entitled to a do-over.
Okay.
That's the bottom line.
Generally speaking, well, now this is where the government is going to suddenly rediscover its reasonableness on the guidelines, because now we have to take into consideration that the circuit court has already said the 11 levels of enhancements under the 1512 were not applicable. So on the guidelines basis, the 1512 suddenly becomes much less serious than even the 111A count.
Right. So if a person,
that's an interesting point, Ship. That's a very interesting
this
point.
is going to end up being a big point of controversy. I don't know that it's going to end at whatever the existing DC, because there's when I looked at this question a while ago, kind of thinking ahead, I came to a dichotomy in the Supreme Court's applications retroactively. The Supreme Court, and it's speaking to us recently, that essentially when it's a constitutional violation, it's retroactive. And if it's more of a procedural change that doesn't necessarily undermine the fact finding of the lower court, then it's not retroactive.
Right.
yeah, but this is going to be retroactive because the rule here is that if the interpretation by the higher court narrows the scope of the people that the statute applies to, then that is substantive and is
Yeah, because you've
retroactive.
got people in jail for something that wasn't a crime.
Right.
Wasn't a crime. Exactly. So they will get retroactive effect immediately. And so folks know, there's these crazy rules when you're doing this stuff after you've exhausted your appeals. Does the thing apply retroactively or not? Sometimes depends on whether the Supreme Court says that it does, but this is the kind of case that there doesn't have to be a second case where the Supreme Court announces that the rule is retroactive. Because it's narrowing the scope of who the statute applies to in the first place, it is retroactive. So people will automatically be able to use it, but if you've already exhausted all of your appeals, you run into the problem that for purposes of collateral attack, you've defaulted out if you didn't preserve this argument below in your trial, which of course half the folks won't have done because none of their lawyers will have made these arguments because the Supreme Court hadn't decided the issue yet, right? So it's sort of a catch-22.
Well, and in
exactly.
fact, the plea agreements required early plea agreements required a waiver of appeal on the issue of whether 1512 was constitutional. I never advised the client to sign that. In fact, I don't think I ever
sign one of those.
I said
right, but I don't think that's enforceable.
I agree.
We look at
Yeah.
the law today, and this is an issue because the government in general, and you've seen this, Bill, more than I have, in its plea agreements says that you waive your right to appeal or to bring a collateral attack under 2255. But there are limits, courts have said, under the extent of a waiver. And one of them is that you can't waive your right to attack an illegal sentence. And if you're convicted under a non-existent offense and given a felony sentence, then that's something that, in my view, you cannot waive. And I think that that's what the courts will rule here.
An interesting point is that this Casso case, ruled on in 2013 by the DC Circuit. The writer of the case is Merrick Garland. And he says at one point that it's not just for you to, let's say you are serving 30 years for murder, right? And then for some reason, he's making an example, but for some reason that statute that you got convicted under for murder doesn't exist anymore. But your other count was for theft, much less. You don't have to prove that you're innocent of lesser offenses because it's just unjust to have to serve 30 years for theft when you got it for murder. So you don't have to prove that you're actually innocent of everything, but only of the greater offenses, more serious offenses. So the DOJ is going to have a hard time arguing against that when the writer of that opinion is the current Attorney General.
So I'm afraid we're sounding a lot like inside baseball, but
Yeah.
basically
Yeah.
what we're
Yeah.
saying is that if the Supreme Court rules in favor of Fisher, that most of the January 6th defendants are going to be able to take advantage of that, regardless of whether they went to trial or pled. That's the
Right.
bottom line.
Unless they have any more serious offenses, which, Ship, as you say, might cover the assaults, right?
Well, it's gonna
Will.
based on the case that you've described, if it's gonna go with a guideline calculation, then
Mhm.
all of the assault, the 111A and B cases are going to be more serious because those are basically you start with a base offense level of 14 and you add 6 for it being a uniformed law enforcement officer executing his duty. So those are all going to be 20 at minimum, and those are longer than so all of these people that are charged with both. I guess you're saying they have to prove actual innocence of the more serious
Yes.
charge, even though that was dismissed,
Yeah.
or
Yes,
they've never been
right,
adjudicated guilty of it.
right.
Yeah. Exactly.
I
For
suspect
on
that's another
habeas.
fight.
Yeah.
But
I'm sure it will.
that's a limited number of defendants.
It's more than you might think. Yeah.
Yeah. So there is, I think, good news for a bunch of people if the Supreme Court goes the right way on this. But now let's talk about the sort of the issue that's lurking behind the issue, which is one that we've gotten questions on the Twitter, on the replies to my original announcement of the spaces, which is, well, what about whether this is an official proceeding or not? Okay. So, because, and this plays into Jack Smith's argument for the former president, which is he wants to say, he, Smith, that even if the Supreme Court says in Fisher that the riot basically is off limits for obstruction, that doesn't matter because I have evidence in my case that was obstructed, like my case against the former president. Now, the reason he's formulating it that way is because literally what is in front of the Supreme Court this week is whether or not this 1512 only applies to the use of evidence. Now, the federal public defender's brief very interestingly makes the argument that this statute from long since time immemorial was talking about evidence in the context of official proceedings, which everyone is kind of easy to understand what a judicial proceeding is, right? It's a trial, it's a hearing, it's a place where a judge is making a decision. That's a judicial proceeding. The statute uses the word official proceeding and then defines that vis-a-vis the Congress by saying an official proceeding is basically a proceeding being held by the Congress. So it doesn't tell you anything beyond still a proceeding. But the public defender's brief is arguing that because this statute has always been in the context of the presentation of evidence, that the statutory analysis for what proceeding itself means, if you take out official and just say proceeding, that means an investigative or an adjudicative activity, not the more general understanding of the word proceeding, which is any kind of activity um, or process. That it means, in a more legal sense, an adjudicative or at a minimum investigative type behavior or activity by the organization, in this case, the Congress. So, literally, the question of whether the certification of the votes on January 6th is an official proceeding is not literally something the court is going to decide in the Fisher case. But the way the federal public defender has argued it, it's a line of reasoning that supports this idea that the statute doesn't make sense unless we're applying it to evidence. Now, I don't expect the Supreme Court to rule in Fisher that the January 6th certification process was an official proceeding. That will probably be left open, but they could say something about it that might be informative about that in light of the way that the federal public defender has argued it. But let's assume, for the sake of this part of the discussion, that they do reverse Fisher and they say yes, we agree with the federal public defender that it has to be something in an evidentiary type context. That's all that this statute applies to. Smith is then going to turn around and say, oh, well, that's what I'm doing, right? Because as Kingmaker pointed out, I have evidence in the form of the elector certifications, the slate of elector, the forms that they signed to send to the Congress. But do we really think that that makes it an official proceeding in the sense of an investigative or an adjudicative function, proceeding in that way? King, what's your view on this?
I think you have to start with how far the Supreme Court goes.
What language they use?
They
Yeah.
could, conceivably hold that subsection 2 is unconstitutional. It is too broad and vague.
Right.
If they do that,
then they wouldn't have to address this
and they never
question
have to
at all.
address this. If they buy the Fisher argument that subsection 2 is limited to the impairment of evidence, then Jack Smith is going to say he's still in the ball game because they have not held that this is not an official proceeding. And I say what is at stake, or what is at issue in the charges against Trump is evidence of who was certified. And I called that bullshit, and I still call that bullshit because it's not evidence. It was designed and meant to be a means to preserve an election contest.
Right. This drives us into, and Ship, I'm interested in your view of this. This drives us into looking at what the Congress was doing that day, right? It drives us into the 12th Amendment and the Electoral Counting Act. So once objections were raised to the votes in Arizona, for example, that was what was on the table at the time that the riot took place. Do we think that that activity, the Congress the houses had separated, they had retreated to their respective chambers in order to rule on the objections? So would they have been taking evidence? What procedure would they have been using in terms of procedural rules for doing that?
See,
How are they establishing the facts on which to adjudicate the objections? Follow what I'm saying, Ship?
yeah, and see, as I was looking at the amicus briefs earlier, it dawned on me that I missed my opportunity to file an amicus brief arguing that the Electoral Vote Act is unconstitutional. It's an unconstitutional
Unconstitutional.
amendment of the 12th Amendment.
Right,
And
exactly.
I actually made this
It's
argument 2 weeks ago in court, and the judge looked at me. It was in closing argument. I started my closing argument with blame Congress. And she looked at me. Those are my first two words, blame Congress. And she
right,
looked at me. It's like, blame Congress for what? I said, blame Congress for creating this idiotic thing called the Electoral Vote Act, which sets
right,
up a day of objections and arguments and expect nobody to show up who has an
right,
interest in the outcome and
right.
displeased with what they hear. Um, so so I think the way they might address this question, if they choose to address it, and remember, if you got 5 votes, you got 5 votes. You control the majority opinion. It'll be in a
Right. And what they're going to say, whether it's what they're deciding or
it'll
not.
be in a
Right,
footnote. It's been
right,
raised in the briefs, so you can't say it's not
right,
part of the record of the case. It's been raised in the briefs. There might be some questions asked, and there may be a poison pill dropped into the footnote that we have real concerns that a ceremonial counting of the votes constitutes a quasi-adjudicative proceeding by which, the impairment of evidence might be implicated.
right.
Um,
This is what I'm thinking
Yes.
too. King, are you following this? It's like,
I'm
okay,
following this,
how
but
is that
I
evidence?
am
Yeah,
I am into this knee deep, or at least,
Only knee, not waist.
at least maybe head deep, because as I drilling down into this, if you Ship's right, I think the Electoral Count Act is or was unconstitutional because it's not consistent with the 12th Amendment, but
Right.
but it had not been held unconstitutional, and Congress was following it, and they followed it back in 1960 when Hawaii, Ship, your
Right.
state, submitted alternate electors, and nobody went to jail then. Nobody got charged with a crime for doing that. It was consistent with what the Electoral Count Act contemplated. Now, the issue really becomes at that point, let's assume it's not unconstitutional. Let's assume that Congress had set aside a day to hear our objections and to decide whether to count the officially state certified electoral votes or to reject them and count the alternate, quote, fake electoral votes. What's the standard? What's the test? What's the burden of proof? Do they take evidence? There's
Right.
nothing
Exactly.
about that. It's entirely
Right.
political, frankly.
Right. I
And
mean, presumably, but what facts are
I
they
don't think
raising?
it
Just facts
matters.
that they take notice of? Does the members of Congress say, "Well, this is what
It, it,
happened," and then they?
it's set up like an adjudicatory proceeding, but there are no rules. There's no no burden of proof. There,
There's no clerk
there's
accepting
yes,
evidence,
there's
right? Yeah. There's no
no
testimony.
testimony, nothing. It becomes a political exercise, which I think is what is contemplated by the Constitution.
Right. So how in the world could that be a proceeding if what we mean by proceeding is an adjudicative decision making process, or at a minimum an investigatory decision making process? So I think this is an open question that the Supremes are not going to want to touch with a 10-foot pole, except maybe Ship, as you say, with a footnote. The federal public defender cited one case on this point. I think it was the Ninth Circuit. So, but reading their brief, I would say that that's probably the only precedent that they found, because they didn't talk about anything else. And in that case, the Ninth Circuit made this distinction between sort of the layperson's discussion of what a proceeding is versus what the legal community considers to be a proceeding. And that in the legal sense, proceeding means investigating, adjudicating, like a formal process where evidence is taken, right? Or acknowledged in some way, and not just sort of proceeding, meaning the process by which we're doing things. So that's something to look out for in the argument on Tuesday, and then ultimately in the decision. What are they going to say about that? And then, based on what they do say, then what is Jack Smith and Judge Chutkan going to do with that in terms of the former president's case?
Leslie, question: Why didn't Jack Smith file an amicus?
Well, I mean, this reminds me of back in the day when I was in law school and we had the old independent counsel statute, which is now no longer exists, where both the special counsel and the DOJ, or maybe it was the Office of White House Counsel, were filing briefs in front of, I think, Judge Silberman, saying, both purporting to be the position of the United States, right? And he was like, I have two briefs here, both purportedly representing the United States, and they argue completely different, contradictory things. And which one of them am I supposed to credit as being from the United States, actually? And that happened, of course, as part of the Clinton shenanigans. But leads me to my point that probably because the Solicitor General would have flipped out if he had done so.
I suspect he would have had to get permission
Yeah.
from the Solicitor General to file a brief on behalf of the United States. He's not an independent actor. He's a special
Even as
counsel.
an
He's a
amicus,
special
even as
counsel.
an
Yeah. He's
amicus,
a special counsel of the Department of Justice. It would have been seen as a Department of Justice brief, and those only come from the Solicitor General.
right. So I really think that would have created a ton of problems. But it would have been entertaining to see if he tried to, what the court would have done about that. So to finish my story, when I was in law school, we studied whether the case that talked about the independent counsel statute, and the Supreme Court found that statute to be constitutional, which it was not. And so I was arguing in my class, well, that's just nonsense because it makes the special counsel the equivalent of the attorney general. That can't be. There can only be one attorney general. So therefore, this statute must be unconstitutional. I think Justice Scalia in dissent was the one arguing this, right? But the rest of the court, that might have been his first year on the court. The rest of the court was like, "Oh no, this is totally constitutional." And then flash forward years later when Judge Soberman, I think it was, is saying, "I don't know whose brief I'm supposed to believe here." My best friend from law school called me up and he said, "Oh my God, now what has happened in real life in that case is exactly the point you were making in law school, which is they can't both be representing the US government. Like that cannot be." So I think with all of that kind of background, probably Smith didn't even consider filing anything. But let me ask you this. Do we think he and or his office had any input with the Solicitor General's office about what went into their brief?
That was
1,000%.
my next question, and I don't see it.
Michael Dreeben is working with with Smith now. Dreeben was the chief deputy solicitor general, so
Right.
1,000%.
So we think there's a back channel
Yeah,
there.
he
Yeah. Right.
worked with him.
Yeah.
But
Okay.
the argument they're
All right.
making, they don't have a fallback that protects Smith very much.
Right. I agree with you. But that, to me, all of their arguments and that fact that they don't have a fallback to protect him is just more proof positive that their argument is just wrong. There's just no way to slice this. Their argument is wrong. So you find yourself as a lawyer making arguments that are absurd, preposterous, that don't protect what you're trying to protect, when that should be telling you you don't have the right argument. You don't have the right side of the
Hey,
case.
I want to jump in here. I'm going to have to drop off, but I want to say one thing before I go.
Yeah, we're almost done. Go ahead.
An attorney whose name appears nowhere in any of this paperwork, but deserves tremendous credit for this issue being pushed up into the district court and then into the appellate court, is Nick Smith out of New York.
Yeah.
Nick represented, I can't remember who he represented. The problem was that the lawyer
was it Warner Bros?
Not Warner
No.
Bros. The lawyer representing Garrett Miller, was a Texas lawyer who I know, Clint Broden. Clint was in trial in Hawaii, which is where I first met Clint. Clint was in trial in Hawaii when the motion to dismiss was due. And Nick Smith had kind of been sort of a ringleader among many defense counsel in these cases back in the late 2021, early 2022 timeframe. And Nick took over writing the brief. He had done a lot of the research. He took over writing the brief that ended up before Nichols while Clint Broden was in trial, because Clint Broden just couldn't do both. And so it was Nick's brief that led Nichols to dismiss the count.
Good.
And then that brief, those arguments were the backbone of 3 cases that went up to the appeals court separately, which was Garrett Miller's case, Joseph Fisher's case, and Jake Lang's case. The court took the Fisher case. The Supreme Court had all 3 of those cases were, after the appeals court had reversed, all 3 cases were dismissed by Judge Nichols, the 1512s. The appeals court reversed, sent them back, and then the Fisher case was the only one the Supreme Court accepted of the 3 that all went up for cert. I think it took the right case, and I've made this point before, and I think Steve will back me up here. Generally, the court's only going to take what it thinks the case where the brief lays out the issues the best. And from a defense standpoint, the defense wants the court to take the case for which the facts are best for the defendant. And the facts of the Fisher case involve a guy who didn't go into the building until 3:24, an hour after the proceedings were stopped. He only went through the East Columbus doors, and he was only inside for 4 minutes. And he got charged with a 1512. That's the case that the court took. Jake Lang's case is a terrible case. Jake Lang's case is Jake Lang is standing in front of the tunnel with a baseball bat and a shield, battling with the police, and he was around for like 4 hours. I don't really know the facts of Miller's case that well, but the court took up the one case out of the three that has the best facts for the defendant, which is typically a good sign. And I just want Nick Smith to get the credit he deserved, because I've talked to him many times. Yeah. I stole his brief that he had used to use myself in a couple other cases. He kind of got taken out of the game here because he was in the main Proud Boys case representing Ethan Nordine, and he was wrapped up in that for like 5 months. And I mean, I tried 2 cases back to back in the same time period he was in the Proud Boys case. So we talked many times about these issues. Nick was on top of all of this stuff. He deserves a lot of the credit for getting it this far. Although the Federal Defender's Office in the Middle District of Pennsylvania, who is on the brief here, did an exceptional job in their briefing.
Yeah, they did. So maybe we could get Nick to talk to us after the case gets decided. That would be
maybe,
fun.
Yeah. I talk to him pretty regularly.
Yeah. Okay. All right. So last question I have for you guys is, do we think that the liberal justices will be on board with the interpretation in favor of the defendant? Because traditionally, the kinds of arguments that this defendant is making with the public defender's assistance are ones that are attractive more to the left side of the court and the libertarians on the court than they are to the conservative parts of the court. So, but given the context here and the effect on the former president's case, do we think the normal rules will apply and the liberals should be receptive to the arguments on Tuesday?
I expect it'll be 8-1. I think Judge Ketanji, or Justice Ketanji Brown Jackson, will side with her former colleagues in the D.C. Circuit. And as I pointed out earlier, when we were talking about the 6 cases the court has taken since 2005, where it reversed all 6 times, 4 of the 6 it did so unanimously. That means Ruth Bader Ginsburg and Antonin Scalia agreed in those cases that the government had overstepped.
Yeah.
And I think we're going to see that here, but I think it'll be 8-1. I think Justices Kagan and Sotomayor will join the balance of the court.
Well, I mean, but Justice Jackson was a criminal defense lawyer. If anybody should be on board with these arguments, it should be her. That doesn't
seem to have slowed down the 15 judges in the district court who all signed on to the government's argument.
Yeah, but most of them were prosecutors before they were on the bench, not defense lawyers. King, what do you think? What do you see?
I think it's possible. It's 9-zip.
I think it's possible too. It's definitely at least 6-3.
Yes,
right?
I agree. I see this as a good case for unanimity or close to it. The only hesitance I have is, how far do they want to go? Do they want to buy in to the unconstitutionality, First Amendment issues? If someone wants to go that road, I don't think it's going to be unanimous.
Right. Steve, do you want to comment on the split?
No.
Yeah, I didn't think you would. So, okay. Well, I kind of see it that way too. Like my experience as a defense lawyer and someone who was in the ACLU for many years, this is the kind of case that if you filtered out the politics, the liberals should be on board with that. This is dramatic overreach by the government and shouldn't be allowed. Justice Ginsburg is a good example. I just don't have any question in my mind about how she would vote, right? If you follow her jurisprudence. So, okay. So, anybody else got any other issues that we think we want to flag for people to listen for during the argument? Okay.
I would
Hearing
say
none.
don't. I
Go
would
ahead.
say don't be. There'll be a lot of hypotheticals try to stretch the boundaries that aren't necessarily going to be indicative. It's not going to be like Colorado. It's not going to be like the Colorado
Right.
case where every judge was kind of calling into serious question the justifications trying to be advanced on behalf of the Colorado Supreme Court's decision, and it was kind of obvious what the outcome was going to be. I don't think the outcome is going to be as obvious from the questioning, even if it's a 9-0 decision.
It could be though, right? And won't the liberals go nuts if this is another Supreme Court argument that, looks like it's going quote unquote in Trump's favor? I just think we're going to have another meltdown if that happens by
Yeah.
the libs.
I think you're going to hear a lot about where are the limiting principles. If they're going to be pressing the government on that, and if the limiting principles is found only in the word corruptly, what does that mean? How far can you take that?
Right.
And does that make this into a thought crime?
Right. I'm not feeling real comfortable. And usually the government will make the argument. Let's see if we hear this one about, oh, well, trust us. We would never apply this statute in ways that were going too far. And, the justices don't seem to be too impressed with that argument usually. But I bet you we hear that. Okay. All right. So let me look at the questions and see if we have missed anything that folks were asking before we sign off. Let's see. Okay, that one we got. That one we covered. About what Smith's thing about the documents. Yeah. No, I think we got it. I will go back through again as I always do, you guys. And sometimes we do miss a question, and then I try to answer them on Twitter in writing. So with that, I think we'll conclude the discussion for tonight. Hopefully this is all recorded fine on the audio and not had those problems. And I will maybe do some editing of it tomorrow to clean it up if need be. So thanks as always, you guys. Steve, Ship, King, thanks for joining in and lending your expertise and insight into these issues. Anybody got any final words they want to say? King, you don't have another
No
story,
more
do you?
stories tonight. It's late.
Okay. All right. Well, good night, my friend. Ship, you're going to close up shop
Nope,
now?
time to go.
All right. All right, Steve. I think it's time for us to sign off. So good night, everybody.
Good night.